Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast, Retroactivity and New Constitutional Rules Edition. I'm your host, Grace Gotchling. On October 16, 2019, the Supreme Court heard oral argument in Mathena v. Malvo, a case which concerns the scope of a new constitutional rule when applied retroactively on collateral review. In 2004, respondent Lee Boyd Malvo was convicted in Virginia on various counts of capital murder due to his participation in the D.C. sniper attacks of 2002. As he was 17 years old at the time, he avoided the death penalty and was sentenced to 4 terms of life imprisonment without parole. In 2012, the Supreme Court held in Miller v. Alabama that sentencing a person younger than 18 to mandatory life imprisonment without parole violates the Eighth Amendment's prohibition on cruel and unusual punishments. In 2016, the court then held in Montgomery v. Louisiana that Miller had announced a new substantive rule applicable retroactively in cases on state collateral review. When Malvo raised these issues on collateral review, the Fourth Circuit held that his sentences of life without parole must be vacated based on Miller, and the cases were remanded for resentencing to determine whether his crimes reflected a permanent incorrigibility that would justify reimposition of the life without parole sentence. This judgment created a conflict with the Supreme Court of Virginia, which had concluded that Montgomery did not extend the applicability of Miller to discretionary sentencing schemes, including life without parole, but only applied Miller retroactively to cases on collateral review involving mandatory sentences of life without parole. The Supreme Court thereafter granted cert to address whether the Fourth Circuit erred in concluding that Montgomery, when addressing whether the new constitutional rule announced in Miller applies retroactively on collateral review, may be properly interpreted as modifying and substantively expanding the very rule whose retroactivity was in question. And now, to discuss the case, we have Kent Scheidegger, Legal Director of the Criminal Justice Legal Foundation.
In 2002, John Allen Muhammad and Lee Boyd Malvo terrorized the D.C. area, gunning down people at random and killing 12 of them. Muhammad, the adult and the leader, was executed for these crimes. Malvo was a few months short of his 18th birthday. Under Virginia law and U.S. Supreme Court precedent at the time, he could have been sentenced to death or life without parole. The jury chose to be merciful, and he was sentenced to life without parole. Now, 17 years later, his case is before the U.S. Supreme Court on a claim that he has a right to resentencing and a chance at a sentence with possibility of parole. Understanding why requires a summary of a long string of decisions. Since the mid-1970s, the Supreme Court has issued many decisions creating many rules for capital sentencing. These rules are ostensibly based on the Eighth Amendment, even though they have no basis in the text or history of that amendment. At the time of the founding, death was the mandatory punishment for murder, and the only safety valve was executive clemency. This complex and frequently changing body of law was expressly premised on the often repeated claim that, quote, death is different, unquote. Justice Scalia famously called it the fog of confusion that is our annually improvised Eighth Amendment death is different jurisprudence. 2 lines of capital cases are important background here. One line imposes procedural requirements on the discretionary choice between a life sentence and a death sentence. The Supreme Court has micromanaged this procedure, even scrutinizing jury instructions. The second line has defined classes of people and particular crimes that are categorically exempt from the death penalty, regardless of the procedure used. These include crimes other than homicide, minor accomplices who do not intend to kill who are swept up in the felony murder rule, persons with intellectual disability, and persons under 18 at the time of the crime. Another line of cases, not limited to capital cases, defines the retroactive effect of new rules created by the Supreme Court. Griffith v. Kentucky in 1987 held that all new rules are fully retroactive to cases that are still on their initial direct appeal. Teague v. Lane, 2 years later, held that new rules of constitutional criminal procedure would not be retroactive to cases that are already final on direct appeal, with the theoretical exception that is never met in practice. Later, the court clarified that the Teague rule does not apply to new rules of substantive criminal law, and that includes categorical exemptions from punishment, such as those I noted previously. Beginning with Roper v. Simmons in 2005, 3 years after Malvo's crimes, the Supreme Court began cutting back on the sentencing of juveniles. In that case, the court created a categorical exemption from capital punishment for killers under 18. 5 years later, in Graham v. Florida, the court created a categorical exemption from life in prison without possibility of parole, which we call LWOP for short, for non-killers under 18. In both cases, the court noted that a categorical exemption and not sentencing discretion that considers youth was required because of the near impossibility of distinguishing at sentencing between, quote, the juvenile offender whose crime reflects unfortunate yet transient immaturity and the rare juvenile offender whose crime reflects irreparable corruption, unquote. In 2012, the court decided Miller v. Alabama, taking a sharp turn. Miller required that for juvenile killers, the sentencer have discretion to impose a lesser sentence, importing into juvenile LWOP the rule that had been applied to capital sentencing for adults since the 1976 case of Woodson v. North Carolina. The court quoted the language from Roper about the near impossibility of judging irreparable corruption, but did not make that standard a constitutional requirement. Instead, Miller made a more general statement that the sentencer must, quote, take into account how children are different. As an aside, I find it really repugnant how defense advocates and sometimes the court refer to teenagers as children. That is not how the word children is used in common speech today, and its purpose seems to be to mislead the public. Although the defendants in Miller were 14, the majority of juvenile killers are 17. In most cases, we're talking about people who could legally be sentenced to death if they were just less than a year older. After Miller, the big question was how far back it would reach retroactively. The Miller opinion itself would seem to answer that question. The Miller court said, quote, our decision does not categorically bar a penalty for a class of offenders or type of crime, as, for example, we did in Roper or Graham. Instead, it mandates only that the sentencer follow a certain process, considering an offender's youth and attendant characteristics before imposing a particular penalty. Put that statement together with the Teague rule, and the conclusion clearly follows that Miller would not reach back to undo sentences that were already final on appeal before it was decided. The court took that question up in Montgomery versus Louisiana. You can't go much further back than Montgomery. He committed his murder when JFK was president. Reading Montgomery, it is evident that the majority was intent on the result of resentencing the remaining prisoners who had received mandatory LWOP sentences as juveniles. Yet Justice Kennedy, who was one of the main architects of the court's retroactivity jurisprudence, probably did not want to dismantle that work, and it is likely that Chief Justice Roberts did not either, and they were necessary votes to the majority. So to achieve the result, Justice Kennedy's opinion for the court needed to pound the square peg of Miller into the round hole of substantive, not procedural law. Such pounding results in deformation of the peg, the hole, or both. In this case, most of the damage was done to the peg. The Montgomery opinion says that the Miller opinion identified a class of defendants, those whose crime, quote, reflects unfortunate yet transient immaturity, end quote, and barred life without parole for that class. Justice Scalia, of course, noted in dissent that the Miller opinion expressly stated it was not creating a categorical exemption, but only requiring a process. He said the majority was simply rewriting Miller, and he was correct. The Virginia Supreme Court tried to get around Miller by declaring that its sentencing process was not really mandatory, as far as life without parole went, because the judge had the ability to suspend the sentence. When Malvo got to the Fourth Circuit on federal habeas corpus, that court assumed that the state court's characterization was correct, but it held, based on Montgomery, that the sentence was unconstitutional despite the discretionary nature, because the judge did not make the determination that Miller supposedly requires in its retroactive operation. At oral argument, it was clear that the Supreme Court was splintered. Justices Ginsburg and Breyer questioned whether the sentence was really discretionary at all. They don't seem willing to accept the Virginia Supreme Court's determination. If that were the basis of a decision in Malvo's favor, it would bypass for now whether Miller has any application to discretionary systems. Justices Kagan and Sotomayor seem inclined to accept Montgomery's rewrite of Miller on its face. Federal constitutional law would then intrude deeply into the sentencing of juvenile killers, bringing in the fog of confusion, as Justice Scalia put it, that we have long seen in capital cases. Justice Gorsuch was skeptical that Montgomery really could have created a factual finding requirement for sentencing. If it did, he says, the Apprendi rule would require that the juries make that finding, and the court probably isn't willing to go that far. Justice Kavanaugh was the most active questioner during the argument, and he may end up as the deciding vote. His position is somewhat difficult to read as he probed both sides. His main question was whether the existence of discretion is enough to satisfy Miller, or whether something more is required as a matter of federal constitutional law. There are a number of ways this case could go. The court could reject the premise that Virginia's system is actually discretionary and vacate and remand for decision on that point. The court could decide that Miller requires only the existence of discretion. That would be true to Miller, but not to Montgomery. Or the court could accept Montgomery as precedent in all its expansive language, whether honest or not, and usher in a new era of scrutiny of non-capital sentencing.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.